Under the duty of fair representation, do I have to represent somebody that's not in the union?
Does the duty of fair representation require that the union take every grievance to arbitration?
Some of the shop stewards and I were discussing grievances and the grievance procedure, and we wondered just exactly at what point do you call in an attorney?
You know, I'm really concerned about the duty of fair representation. I'm representing a member in a grievance right now, and if I screw up in this grievance handling, am I personally in trouble?
The duty of fair representation. You may have heard about this concept at a union meeting or a convention or in a training workshop. And like other local union officers and stewards, you may have wondered, what does it mean and how does it affect me? Well, that's what this program is all about. Hello, I'm Catherine Ezon for the AFSME Education Department. Over the next few minutes, we'll look at the origins of the fair representation concept. We'll show how it applies to your role as a local union leader. We'll answer some of the questions union stewards are asking. And we'll present a grievance action plan to help stewards meet our union's responsibilities. To understand the duty of fair representation, we must turn to history. In particular, history that has been written in this building, the United States Supreme Court. For unlike many other labor relations principles which are found in laws enacted by Congress, the duty of fair representation emerged from a series of court rulings.
The concept of fair representation actually got started a long time ago, and not under the National Labor Relations Act. It got started under the Railway Labor Act in 1944 in a case called Steele versus Louisville and Nashville Railroad, and it had to do with racial discrimination against a black worker who was denied fair representation by the union in a promotion decision.
A group of black railway workers filed suit. The Supreme Court agreed with them, and a negotiated contract that clearly discriminated against blacks was declared invalid. The High Court implied that the union had a legal obligation to represent all employees in the bargaining unit. In this and other early cases, the court focused on the union's representation duties. Later rulings in the 1950s and 1960s emphasized the principle of fairness.
A whole series of court cases extending the idea of fair representation from its initial idea of rather blatant discrimination on the part of the union to a number of actions on the part of the union having to do with bias, with negligence, with discrimination in one form or another, essentially with bad faith in representation in both bargaining contracts and handling grievances.
In 1983, in a case involving the Postal Workers Union, the Supreme Court issued a ruling known as the Bowen decision. Here, the court found that unions must be consistent in carrying out their representation duties.
The Bowen case is an important case because it did, in fact, sensitize the unions and sensitized those in the labor movement with regard to the union's responsibility in fulfilling its fair duty obligations.
4 decades of Supreme Court rulings can be boiled down to one basic principle, which is this: when a union has the exclusive right to represent employees in a collective bargaining unit, it also has a special responsibility.
The duty of fair representation really refers to the union's obligation to represent everybody within the bargaining unit without regard to race, creed, sex, color, national origin, or union membership or non-union membership.
The duty of fair representation includes representing people whether they're union members or not, and it also includes handling cases in a way that isn't arbitrary or neglectful. We have to make a good faith effort in all of our representational functions.
It used to be, before there was so much concern about the duty of fair representation, that the union would say, well, I'm supposed to represent non-members, but I will show a little less enthusiasm in representing them than I do in representing members. You can't do that anymore. You shouldn't do it anymore. You must represent everybody equally, everybody equal.
A union must meet its duty of fair representation in two arenas. The first of these is contract negotiations.
So we'll take care of the flex today, and that should be it then. Right on. Great.
We have to be mindful of representing all of the interests of the bargaining unit, or the interests of all of the groups in the bargaining unit, so that the obligation of fair representation at the table means that we have to not discriminate or be arbitrary about decisions we make that affect certain members of the bargaining unit.
It doesn't mean everybody must be treated exactly alike. For example, higher seniority workers get longer vacations. They accrue more pension credits. There are certain preferences in promotion, transfer, and so on that accrue with seniority. This is understood.
We all recognize, including the courts, that the process of collective bargaining is a process of give and take, and that some issues will be subordinated and considered less important than others.
It'll work. Right now, the only reason we haven't been really successful is we did.
But as long as the union acts in good faith, without a discriminatory or a hostile motive, I think the union has nothing to be concerned about, so long as it is attempting to implement the desires and wishes of the membership.
Right.
Yeah.
So it might be worth.
Yeah, you know, if I go upstairs to Teddy,
Two stores, as a matter of fact, me and...
Contract negotiations affect the bargaining unit as a whole, but the steward is more directly affected by the second application of the duty of fair representation.
Turns out that the brakes were unsafe, and we have that in writing.
So we're going to have enough documentation to support us.
That's because it's the steward who handles most of the employee problems that arise on the job. It's the steward who knows the contract and enforces its provisions by processing grievances properly and fairly.
He called you into the office. He was yelling at you. Okay. Was his language abusive? All right. Fine. Tell me exactly what he said to you. All right.
And the steward has to apply the standard tests of what constitutes a grievance. A violation of the contract, a violation of past practices in the work environment, unfair treatment, whether or not it has been specifically covered by a past practice or whether it's specifically covered by the contract. The steward looks at that and decides whether there is a basis for a formal grievance or not.
Great. Remember, well, I'll take care of everything. Everything will be handled. Just think
There are two basic things that I think a steward has to do. First, you need to look at the contract to see whether or not there has been a violation. That's probably the key thing. If there is contractual language that gives the employee a right and therefore a grievance might be appropriate, we also need to look at the facts to see whether or not the facts of this particular situation support the grievance.
To help determine whether or not a grievance has merit, there are two questions that stewards should ask themselves. Has there been a violation of the employee's rights? Is there sufficient proof that the violation took place? If the answer to both of these questions is yes, the steward should pursue the grievance. On the other hand, the union has no obligation to pursue grievances that are totally lacking in merit or which have no chance for success.
We have to be mindful of our credibility and how the union appears as it represents the entire bargaining unit. And if stewards file frivolous grievances, it may cause a long-run deterioration of our credibility and our ability to effectively represent people when real grievances exist.
The critical point to remember is that the decision on whether or not to pursue a grievance cannot be based on any type of discrimination. Stewards should make their decisions in a thoughtful, consistent manner. We observed earlier that this program's topic has stirred up some questions among stewards who want to make sure they are fully representing their co-workers. Let's take a couple of minutes now to get some answers to these concerns.
Some of the shop stewards and I were discussing grievances and the grievance procedure, and we wondered just exactly at what point do you call in an attorney?
In the grievance procedure, you don't need lawyers. You are interpreting the union contract, past practices, things about which the steward knows more than the outside lawyer knows. So you don't need a lawyer for the grievance procedure. Furthermore, it fouls up the grievance procedure because you get a kind of competition to win instead of to settle.
You, as a steward, are trained to represent employees, and you know your contract very well. You have the ability to formulate grievances and file them. And I think that you should not rely too heavily on lawyers, because you really are on the front lines doing the major work for the union.
There is never any particular point where an attorney should or must be called in. I'm aware of many situations in which union representatives handle the processing of a grievance in a very thorough, efficient, competent manner from beginning to end. There are other cases which are peculiarly difficult or peculiarly unique where a union feels that the services of an attorney are warranted. I think this is a decision that has to be made on a case-by-case basis.
Does the duty of fair representation require that the union take every grievance to arbitration?
Absolutely not. We do not have to take every grievance to arbitration. We do need to take those grievances to arbitration that have merit to them, or that will be important for the bargaining unit as a whole, or for the particular employee who's filed the grievance.
After evaluating the case, weighing its merits, considering it in terms of relative priorities, vis-a-vis other cases that are pending, the union can make a determination as to proceed to arbitration or as to not to proceed to arbitration. But categorically, I think it's imperative that we understand that the union need not take every case to arbitration.
I'm representing a member in a grievance right now, and if I screw up in this grievance handling, am I personally in trouble?
In fact, the rule or the guidelines about duty of fair representation require that we make our best effort, that we use our best judgment and make an honest effort at fairly representing employees, so that you don't need to be perfect in your representation. You just need to do the best job possible.
The courts recognize that mistakes may be made, but fortunately they have also recognized that mere negligence or inadvertence or oversight is not tantamount or equal to breaching the duty of fair representation. What the courts are really interested in looking at is ascertaining whether or not the decision by a steward or the actions by a steward were made in good faith. If they were made in good faith without consideration to hostile factors or discriminatory factors, I think a steward can be very comfortable in the fact that his actions will not result in personal liability.
AFSME represents an entire alphabet of job titles and classifications, from account clerk to zookeeper and almost everything in between. Even more significant for the steward, units that we represent are made up of all different kinds of people. Employees from different backgrounds, people with different ideas and values who bring different attitudes to their jobs. Yet there is one common link between all these employees, no matter who they are or where they work. On any given day, any one of them can walk up to the union steward and announce, "I want to file a grievance."
And I know for a fact that Bill and Jack
As a steward, you are taught and trained to pick up your pad and pencil and start investigating.
I'll go see your supervisor and I'll see if I can get to the bottom of this.
But as any experienced steward can tell you, personal feelings sometimes intrude into the scene.
Hey, Glenda, you're just the person I want to see. You're my shop steward. I want to talk to you.
Oh, no. Here comes Jack again. This guy's a pain in the neck. Nobody can stand him. He's never joined the union. I should just tell him, get lost.
This guy's making me sick, Glenda. He gave me a written reprimand to put in my file. I don't think I deserve it. A lot of guys do a hell of a lot
What if I
worse things
just
than I do around here.
accidentally
I don't think I deserve this.
forget
I
the
think it's about
time limits and
I filed
don't file the grievance in
I
time?
don't think I deserve
Maybe
this.
I just won't be able to find the time to talk to any witnesses.
Things
Or I
that
could
do, and
just
he
tell
never
him
says
that I'll
anything
take care of it.
He looks the
And
other
that'll
way.
be
He
the
never
end of it.
bothers them at all. But every time I do something, he comes around. And now he tells me he's going to put this written reprimand in my file. And this time I want to file a grievance. I'm just not going to stand for it anymore.
Okay, Jack. Come and see me on your break time, and I'll see what we can do about it.
You bet your life I will. In the meantime, you can look that over and tell me what you think of it.
I think I'll just file the grievance, and then just go through the motions. That way he can't say the union didn't do anything.
If this steward follows any of the courses of action she's considering, it's clear the door would be wide open for the employee to claim that the union had breached its duty of fair representation. On the other hand, if the steward simply does her job of investigating and preparing the grievance, she and the union will have met their responsibilities.
The steps that a steward, a union representative, can take to avoid being charged of a violation of the duty of fair representation, simply to do their job right, do their job conscientiously, file the grievances on time, not be negligent in filing a timely grievance if that is required, necessary, not discriminate against somebody because they don't like them for political reasons, for personal reasons, for whatever. Be even-handed in the way you treat workers. And if you turn anybody down on a grievance, have a sound factual basis for doing it. In other words, be in good faith.
Just keep in mind that your course of action in any grievance should be determined by the merits of the grievance and not by the merits of the person who wants to file the grievance. To help meet your responsibilities, here is a 5-step grievance action plan that you can follow. Thoroughly investigate the grievance.
And give me all his hard times over everything I do.
You ever had a run-in with him?
Yeah, you know, I mean,
Listen to the employee. Be sure and write down all the facts and circumstances. Use a grievance fact sheet to determine the 5 W's: who, what, when, where, and why.
Okay, did anybody happen to call you during the time?
Not that I know of. Not that I know of. He said that somebody called me.
Review your contract to see if a violation has occurred.
But did you actually see him?
Don't forget to interview potential witnesses, both employees and management. And of course, examine the employee's files and any other documents which might help in the case. If the union decides to drop a grievance for lack of merit, immediately notify the employee. This can be done in a number of ways. For example, some local unions mail the grievant a certified return receipt letter. Whatever the method, the grievant should be told the reasons for the union's decision, and the grievant should be informed of any internal procedure for appealing the union's decision. If the union decides to pursue the grievance, be a strong advocate for the employee.
I think you need to know that management is at fault in this whole situation. They did not bother to check out his story. I did an investigation.
Don't just go through the motions when presenting the grievance. At the appropriate step in the grievance procedure, argue the employee's case earnestly and in good faith.
But I don't think you want this case to go that far. In fact, all management has to do...
Remember that you're not only representing an individual grievant, you're also enforcing the union's contract.
He's got a good work record. If you look at his folder, you'll see that there have been no other problems with him.
Follow the contract regarding the grievance procedure. Every contract contains specific grievance steps and clearly stated time limits for filing and appealing grievances. Know these time limits and follow them to the letter. Many stewards keep a special grievance calendar to help them keep track of time limits.
An agreement's assigned.
Just extending the time limits.
If you or the employer want to extend the time limits, always do so in writing.
See everything's listed there.
All right, well, if you think you...
Maintain a written record of the progress of each grievance, including time limits and decisions. Most stewards ask the grievant to sign or initial the record or grievance form at each step of the process.
What I need is to have you sign so that we can appeal it to the next step. Okay?
Tell the grievant that he or she can provide additional evidence as the case progresses.
Okay.
Thank you.
By following a grievance action plan, you can be confident you are fulfilling the union's obligations, and you will be helping your coworkers resolve their problems and grievances. You know, most stewards realize that grievance handling is not simply one of their responsibilities. It's one of the best ways to preserve and build your local union.
My feeling is that if a non-member's rights are violated, then management could also take advantage of the rights of union members as well. So everyone should be fairly represented.
I just feel I'm doing a job for the union, and maybe I'll make him, by representing him, he will become a member. He will want to become a member of the union.
If an employee came to me and they were a non-member of the union, I wouldn't be angry or anything. I would still represent them the same as I would represent somebody else. They're still my co-workers. I would want my reputation and the reputation of the union to be outstanding, so I would still do the best job I could.
For stewards who handle employee problems and grievances, here's a final checklist. Always act in good faith on the merits of any complaint. Thoroughly investigate, document, and prepare each grievance. Follow the contract, especially time limits. Keep the grievant informed. Yes, the job of steward is a challenge indeed. Following our program's guidelines can help you meet that challenge and strengthen your union.